Good afternoon, and thank you for joining this webinar entitled Juvenile Defenders and Civil Legal Aid Attorneys Collaborating for Record Clearance. My name is Alex Lessman, Policy Analyst for the Criminal Records Project at the Council of State Governments Justice Center. The Council of State Governments Justice Center provides practical, nonpartisan, research-driven strategies and tools to increase public safety and strengthen communities. Before getting started, I'd like to go over a few housekeeping points about how the webinar works. If you encounter any technical problems, including audio problems, during this webinar, please call WebEx Technical Support at 866-229-3239. That number again, 866-229-3239. This information is also located in the chat box on your screen. Please understand that there may be some individual technical problems we cannot resolve. For this reason, we are recording this webinar and will post it on our website at cleanslateclearinghouse.org, where it will remain accessible. At any time during this webinar, you can ask a question by typing it into the Q&A box at the right of your screen. This includes both technical and content-related questions. We will reply to technical questions as we go. For content-related questions, we will keep a running list and the presenters will address them at the end of the webinar. We will do our best to get through as many questions as possible. Today's presenters are Serena Holte, Senior Staff Attorney and Pro Bono Counsel at the National Juvenile Defenders Center, Karen Pillar, Managing Attorney at Team Child, and J.C. Dye-Klabundi, Attorney in the Juvenile Reentry Project at Legal Aid of Nebraska. We will be hearing from them shortly. This webinar is part of the Clean Slate Clearinghouse, a project funded by the U.S. Department of Labor and the U.S. Department of Justice. The Clean Slate Clearinghouse was created to support juvenile and adult criminal record clearance around the country by, first, providing up-to-date information on record clearance as well as contact information for legal service providers in all U.S. states and territories. Second, developing tools and resources for legal service providers currently doing record clearance work or those who want to expand their record clearance services. And third, providing information to compare record clearance policies across jurisdictions and to learn about best practices. The site was designed to serve three target audiences: people with criminal records who are seeking to have their records cleared, legal service providers who offer record clearance services, and policymakers and stakeholders who want to compare record clearance policies across the country. The site is useful for reentry and workforce service providers who can connect people to services, for indigent defense attorneys and pro bono attorneys who are interested in starting or expanding a record clearance practice, and for researchers and journalists who want to compare trends in record clearance legislation across the country. The primary goals of the Clean Slate Clearinghouse are to provide accessible, up-to-date information for record clearance policies across the country and to increase the capacity of legal service providers while creating a community of practice for those doing record clearance work. We encourage you to visit the website and sign up for our newsletter to stay updated on news, events, and webinars such as this one. Now, I'll turn it over to the first presenter, Serena Holte.
Hi, everybody. Today's webinar is on the collaboration and the need for collaboration between juvenile defenders and civil legal aid attorneys to increase the record clearance for juvenile records. The consequences of juvenile court involvement are actually numerous and far-reaching, and they can prevent a young person from fulfilling their educational, social, and professional potential. Youth left to overcome these obstacles on their own face significant barriers. And partnerships between legal aid attorneys and juvenile defenders actually offer opportunities to pool expertise and ensure youth facing collateral consequences get essential legal representation. Juvenile courts handle approximately 1 million cases per year. And in many of these cases, young people are not represented by an attorney in violation of their constitutional right to counsel. This means youth may have a record simply because they did not have an attorney to represent their interests and advocate for them in court. And in all but 11 states, children lack meaningful access to lawyers post-disposition. That means after the time in which they've received their, what in adult court would be called sentence. Young people are not receiving access to lawyers to help them navigate appeals, probation, reentry, collateral consequences, and more. Youth in every state face collateral consequences because of involvement with the juvenile court system. These consequences are unique from the criminal justice system, primarily because they actually defy and prevent the rehabilitative purpose of juvenile court. Few juvenile court stakeholders, and not to mention young people, understand the breadth of harm that youth face as the result of their court involvement, and this lack of understanding underscores the need for knowledgeable and passionate advocates. Why is record clearance important? Just because of what I mentioned about collateral consequences. It's a myth that juvenile justice records remain secret. Very few states actually hold all juvenile records as confidential. The vast majority of states make at least some juvenile law enforcement and court records available to the public. This access creates significant impediments for young people pursuing higher education, employment, and housing. Once a record is public, the damage is far-reaching because anyone can access the record and use it as a reason to deny youth opportunities. While a juvenile disposition is not synonymous with a criminal conviction, that distinction is actually lost when the record appears on a background check or is disclosed on an application. Simply because the records can be publicly accessed, youth in almost every state face harsher and more long-lasting punishment than that what was ordered by a judge in the juvenile court case. Even when the records are not public, youth still face collateral consequences. Sometimes schools or housing authorities are notified of a youth's juvenile court involvement, or a young person is required to disclose their record on an application or in an interview. The school or college, landlord or housing provider, state licensing entity, or employer can then use that information to deny the youth education, employment, or housing. So what are some of these common collateral consequences that young people face? Many of the things that you see listed here are things that you would see as collateral consequences in the adult arena. But, you know, juvenile court was actually established as an alternative to the punitive criminal system to support young people's individual strengths and help them on a path to success. It's supposed to have a different purpose than the adult criminal system, which is mostly punishment and a little bit of rehabilitation. However, the collateral consequences of a juvenile adjudication doubly punish youth by limiting their ability to move forward after they've complied with their court order requirements. Collateral consequences are the byproducts of juvenile court involvement and affect practically every aspect of a young person's life, including employment, housing, and education. And these consequences disproportionately harm youth who are already most at risk: youth of color, LGBTQIA, and C youth, and youth involved in both the dependency and delinquency systems, youth experiencing homelessness, and youth with physical or mental differences. Partnerships between civil legal aid attorneys and juvenile offenders can be a dynamic and powerful way to help youth tackle these barriers to success. We're going to talk a little bit about some of these barriers more, but really we could go on for an hour or two or more to really emphasize what these things all mean. But just to highlight a couple that are specifically important for people to understand about barriers that are created by juvenile records. There are oftentimes barriers related to education. The Common App is an application that is used by over 600 colleges and universities nationwide, so that a young person can fill out one application and apply to several different colleges, instead of the young person having to go and fill out every single college's individual application. Now, that sounds great, but for a young person who has a juvenile record, that can actually create a problem because the Common App asks about juvenile adjudications. However, it gives an opportunity for the young person to deny the record if the young person has been able to get their record sealed or expunged or whatever the record clearance term is in your state. Another example is fees, fines, and restitution. Young people will oftentimes have fees, fines, or restitution as ordered in their juvenile court case. Sometimes these can be tremendously huge amounts. We have had experience where we've seen where it's been over $100,000 for a young person. And sometimes for a normal case where, many young people have taken a car to go joyriding and unauthorized use of a vehicle and ended up maybe damaging or totaling that car and had restitution amounts that were many thousands of dollars. Or even court fees and fines. Young people are required to pay $100 for a DNA test, $200 for the case just being filed, and sometimes they're even being charged for the defense attorney to represent them, even though the attorney is supposed to be representing them, quote unquote, for free. So there are many consequences that we're talking about, but what we see is that record clearance in many of these circumstances can make a difference. And I'm going to give you a couple examples of where that's true. To bring the issue home and to help you get a better understanding of what we're talking about, let me introduce you to Robbie. Robbie was adjudicated 9 years ago, and since then he has completed high school and earned his associate's degree in information technology. He now works in construction. To support his ailing mother and his young daughter, he continues to apply for jobs related to his degree, but despite his impeccable employment history and references, potential employers continue to deny his application after running background checks that reveal his juvenile record for disorderly conduct. How can Robbie pursue his career when his juvenile record repeatedly blocks opportunities for employment in his chosen field? This is an example of a real-life individual who has, obviously we changed the name, but who has great potential and has earned his way up, done a lot of wonderful work, graduated with a degree in information technology, and is struggling to find a job in that field that can actually help support his young daughter and his ailing mother. In contrast, he ends up working construction. What ended up happening was that Robbie went back to his juvenile defender and asked what he could do, what he could possibly do to help deal with the situation. Eventually, they were able to get his record cleared, and then it would no longer show up in the background checks. And then, Haima. She's 18 years old, a new mother, and recent high school graduate. She's been working for a few years at a local diner, part-time while she was in school and full-time for the last month or so. Recently, she and her mom have been fighting quite a bit, and she's scared that her mom is going to kick her out, and she's just not sure where she would go. She doesn't have enough money to pay for an apartment on her own, which would require first and last month's rent, in addition to a deposit that's also equal to a full month's rent. That's 3 months' worth of rent due before she'd ever be able to move in. And she's been told her juvenile record will keep her from being accepted into public housing. How can she find stable housing for herself and her new baby when her juvenile adjudication can be used as a reason to deny her housing application? This young lady was really struggling to get by, and what we've actually discovered from a lot of the research is that young parenting teens are often ones who will end up homeless. And this is a circumstance where her juvenile record is one of those reasons that's perpetuating her having a housing instability problem. I wanted to give you guys examples of real-life situations of where these issues are becoming problems, and also what we can do about it with record clearance. So there are a wide variety of records that we're talking about that could potentially come out and cause problems later on when we're talking about juvenile records. There's public records and there's confidential records. So a large majority of states actually have some level of juvenile records that are available to the public. There's 6 states that have all records available to the public, and under 10 that have records that are pretty much confidential and unavailable to the public. So young people could potentially end up with public juvenile records. There's also police records. Sometimes police records or law enforcement records are available to the public in a way that the court records may not be. They may show up in a background check run through the state police. And then there's fingerprint records. If a young person is arrested and required to give their fingerprints, what happens to that record? And the same with the DNA. When their DNA is taken, what happens with that record? Many times these are shared with the Federal Bureau of Investigation, and then they're no longer underneath the auspices of the state law enforcement and could be shared even wider. Many states also share information with their local Department of Motor Vehicles or DMV or Motor Vehicle Administration, whatever it's called in your state. There's times where those records could also indicate that a young person has a juvenile record. Now, there's all sorts of names for record clearance. There's sealing and expungement, expunction, destruction, deletion, vacating, erasure, set aside, whatever the name is. It varies and the functions vary. Sometimes something may be called sealing, but seem to function a little bit more like what you would normally think an expungement functions like. Now, who's eligible? It varies by state. Who can get their juvenile record cleared and what the exceptions are to eligibility. What offenses may leave a person unable to get their record cleared? What is the waiting period required for the person to wait before they're able to ask to get their record cleared? Is there a fee required? Does the young person actually have to go back to court and request that their record be cleared? Or is there an automatic clearance process? What records are actually cleared? Are they just the court records? Will there still be police records available? What are the records that are actually destroyed, set aside, or sealed? And when we're talking about juvenile records, one of the ways that things might be able to get out is, does it include all those lists of records that we just talked about? Or is there one that may be slipping through the cracks? Can the youth now act as if the offense never occurred because they got their record cleared? Will they not have to self-disclose this on an application for housing? Will they not have to self-disclose on an application for college? All these things make record clearance very important for a young person who's been through juvenile court. Partnership between civil legal aid attorneys and juvenile defenders can be a dynamic and powerful way to help youth overcome the immensity of problems they face following their juvenile court involvement. Collaboration allows each to tap into their own strengths and expertise and work together to strengthen the future opportunities available to young people. Juvenile defenders. Defenders have expertise in representing youth and in the juvenile court system, but are often statutorily barred from or ill-equipped to offer representation in record clearance matters because these matters are often considered outside the scope of constitutionally required representation. Defenders may be prohibited from such practice either by statute or in their contract or in internal policy. However, many juvenile defenders handle record clearance matters when that process can be initiated soon after the juvenile court case is complete. But that's just not how the process works in many states. Some states have waiting periods that are 3, 5, even 10 years later after the case is over. Civil legal aid attorneys are actually experts in handling civil issues and understand housing, public benefits, and health systems, which may play a large role in the young person's life. Legal aid attorneys can screen existing clients with a history of juvenile court involvement for record clearing eligibility. This screening is especially helpful in cases where a young person is not eligible for record clearing until years after the case is closed and is no longer in contact with the juvenile defender. Legal aid attorneys can also help with record clearance in less conventional cases, for example, where legislation makes new offenses retroactively eligible for clearance. Civil legal aid and juvenile defender offices can actually collaborate to review old files, identify eligible clients, and strategize how to initiate record clearance. We've had many great examples of record clearance partnerships, and they come in many different forms. So here's some examples of where we've seen these partnerships. Young people could benefit significantly from coordinated efforts to clear their records. Juvenile defenders can offer to train or advise civil legal aid attorneys on adolescent development and the interconnection between collateral consequences of juvenile court involvement and record clearance. Civil legal aid attorneys can offer training or advice to juvenile defenders on other systems that affect a young person's life, such as housing, public benefits, health. And legal aid attorneys and defenders can conduct joint record clearance events or clinics. And in many cases, a legal aid attorney will not be able to access confidential records independently to determine eligibility for record clearance, but juvenile defenders usually do have access to those records, showing the importance of both working together. Now, there's examples of juvenile record clinics throughout the country. It's worked in all sorts of different forms where people have come together to, on a monthly basis, bi-monthly basis, a couple of times of a year, where they have events all about educating people about their records, what can be cleared, helping them fill out the paperwork for it. There's pro bono projects. There's many organizations who have started coming together to do the intake work and then have been able to find pro bono attorneys to help take on the case representation itself. Joint outreach and educational events, both legal aid and defenders can work together to make sure that we're reaching the community. What good is record clearance if people they don't understand that it's available, and if they don't know what they can do to get their record cleared, or even why it's important, and to serve as ongoing referrals for one another. They host externally funded fellowships. So, for example, the last couple of years, National Juvenile Defender Center was managing a grant from the Office of Juvenile Justice and Delinquency Prevention, where we hosted fellows throughout the country who were focused on providing civil legal services to young people who've been in the juvenile court system. Every single one of them was providing record clearance services, and that occurred in 6 different states. We worked and made sure that everyone, whether they were at a public defender office or a civil legal aid office, that they were partnering with their counterparts in the other, because otherwise things were going to slip through the cracks and they weren't going to be able to be as effective as they could be. And today we have with us 2 great individuals who've had experience with partnerships between civil legal aid offices and juvenile defender offices. First, we have JC from Legal Aid of Nebraska.
Hi, everyone. My name is JC Dyke-Labundy, and I am the Juvenile Reentry Attorney here at Legal Aid of Nebraska. And to add to today's conversation, I must say that our juvenile reentry project started off in Lancaster County here in Nebraska a couple of years ago, and it's now expanding into Douglas County. But what made it even possible to start to take the route to expanding the project was the relationships that were created and fostered by the attorneys that have worked on this project. And in particular, that relationship and collaboration that was made between Legal Aid of Nebraska and the Lancaster County Public Defender's Office, specifically those public defenders who worked on juvenile cases. From them, we were able to get referrals, get connected with youth, as well as get the word out that we have this project available for youth that specifically works on sealing youth records and assisting them with the collateral consequences of having a juvenile record, which not a lot of attorneys in Nebraska were doing then or do now. And the reason that this work, and in particular sealing juvenile records, is so important in Nebraska is because a youth record is open to the public here until it is sealed, which is a fairly big deal. So before this project and this partnership between our office and the Lancaster County Public Defender's Office, a lot of times what would happen here is that juvenile cases would move into a post-dispositional phase, or it would close, and their access to their appointed attorney would end. And after that is when generally the sealing process would either be initiated or the youth would have their juvenile record affect them in some way. Now, if the sealing process was initiated and objected to, or if their record was negatively affecting them in some other way, then that youth, or at times their family or support system, would try to go to that previous attorney to see what was happening, what they were getting notice of, or trying to find out what they were supposed to do. And unfortunately, since these attorneys were already off their cases, there wouldn't be much that they could do besides possibly giving them limited information as to what a sealing was. And then the issue on our end here at Legal Aid is we weren't connected with these youth the way that the Public Defender's Office was. We didn't always know how to get a hold of them. And in regards to the notices that the court would send out about the sealing process, those were generally sent to the county attorney and the Public Defender's Office and the youth themselves. And they weren't something that we at Legal Aid here on the Juvenile Reentry Project were privy to. So what happened is once we started collaborating and working with the Lancaster County Public Defender's Office, was they would send out information to these youth, letting them know our services were available, or if they directly talked to these youth, again, they would give them our information and referrals, especially when they got notice that that county attorney was objecting to the sealing. So we then were able to start providing representation for these youth at these hearings and assisting them through that sealing process, which is fairly confusing here in Nebraska, and then also helping them with other civil legal issues that were collateral consequences of having that juvenile record that their public defender wouldn't have been otherwise able to assist them with, such as housing and employment and education. Also through this process, we were able to make more systemic changes because of the things that we discovered when working with the Public Defender's Office that we might not have otherwise, such as the number of dismissed cases that clients referred to us had that were not sealed that should have been automatically sealed. As well as this presented a better opportunity to make sure courts here were informed of the amount of ways that a juvenile record really can have multiple collateral consequences on a youth trying to achieve success after leaving the juvenile justice system if their record was left open to the public. So all in all, this collaboration between the two offices has been really essential in helping these youth and helping as many youth as possible get their records sealed and be able to move forward and lead successful lives without having their juvenile records affect them at every turn. And our project would not have been as effective without us working together to try to help these youth from multiple different angles.
Thanks, JC. And you know, that is a prime example of where our system has in many turns and twists failed our young people, but where we as defenders and civil legal aid attorneys can come together and try to help youth overcome those obstacles and failures of the system. You know, the Public Defender's Office was not allowed by contract to be able to represent young people in these sealing matters, and the fact that legal aid was willing and able to take up that issue and is now the champion of juvenile record clearance in Nebraska has made a huge difference. And as JC mentioned, in Nebraska, juvenile records are available to the public, so it's very important to ensure that young people are getting access to record clearance and making sure that they get an attorney to help them through much of that. So another amazing example is Team Child in Washington State and how they have partnered with many entities, but definitely the public defender offices throughout the state. Karen?
Hi, thanks, Serena. So I'm Karen Pillar. I'm a managing attorney in our Team Child King County office, and we have offices in 4 counties in the state of Washington. And we have had a variety of partnerships to address record sealing for juveniles. I just want to maybe contextualize it by saying, as a legal services office, Team Child started in partnership with public defenders. So the whole idea behind our civil legal advocacy for young people was born out of a partnership with public defenders who were seeing young people face many obstacles in the community around education, housing, health care, mental health care, disability-related services. And so providing civil legal services to young people who had juvenile justice contact is something, I mean, that's what Team Child does. And then the other context I think is important is the state of Washington didn't make juvenile record sealing available until fairly recently, certainly in less than 10 years. And so when the state law changed to allow for the sealing of juvenile records, one of the first collaborations Team Child had was actually with it was with public defenders statewide in order to change the law. So actually our advocacy is as civil legal attorneys helping young people and partnering with public defenders who are defending juveniles. It was that collaboration that helped get the state to start changing the laws and start allowing for juvenile record sealing because of all the negative consequences that Serena's already covered. So that was really our initial partnership, was on legislative advocacy. And then once the law changed, we partnered actually first with a law school, actually a couple law schools, locally in King County to start a clinic. And we ran it as a pro se clinic, so we had a lot of law student volunteers. We had to have public defender volunteers because they helped us get access to the juvenile record. And then we had Team Child attorney volunteers and other attorneys in the community who wanted to volunteer. And we ran a monthly evening clinic for several years where people could come and fill out all the paperwork necessary to file a pro se motion to seal their record. That model is somewhat reflected then in our Spokane County office, which is runs their clinic in partnership with Gonzaga Law School. And so they make record sealing available through a clinic that's also supported by the law school at Gonzaga. So we've had a couple partnerships with law schools. Our Pierce County office actually partners with the local Bar Association, excuse me, pro bono program. So a lot of the record sealing for juveniles that happen in Pierce County includes a partnership with the local bar. Now, each of these clinics has to have public defender involvement because they do help access the record that we need to assess eligibility for sealing. But those are some of the things we've done here. We also had a fellow with the support of NJDC to focus on post-conviction relief for young people for a year. That partnership has really helped to inform the work for everyone, attorneys across the state. And I think actually was pretty instrumental in getting the public defender bar here in King County to negotiate in their own contract to be able to continue to do post-conviction relief as public defenders for juveniles. So one of the biggest successes we've had in our state since allowing juveniles to seal their record, giving them that opportunity, is that the local public defender office in King County, which is Seattle, they have now amended the contract they have to allow their juvenile public defenders to complete the record sealing process for their clients, basically, for people they represented originally in the defense. And that has been an awesome change in perspective. Of course, that's not happening statewide. We'd love to see other public defender offices kind of move in that direction, because there's still many places in our state where getting legal advocacy to help seal records is not available. But as a civil legal services office, I would say that addressing the collateral consequences of juvenile justice, specifically addressing record sealing, and in our state we also address relief from registration if you're a sex offender, and reduction of restitution, because you can't, in our state, you can't get a sealed record unless you've paid your restitution. And if your restitution is something you'll never be able to pay, then you'll never be able to achieve that outcome. You know, as a civil legal services attorney, we see the work of addressing collateral consequences as a civil legal need, because of course a significant portion of civil legal problems young people or anyone faces actually can be tied to juvenile justice or criminal justice involvement, right? If you owe too much money in fines, if you lose your driver's license and due to fines, and then you can't get a job, and then you can't pay your rent, and then you get evicted, right? There's sort of the core of many civil legal problems that we see are tied to people having criminal or juvenile justice interface, right, and the impact of that. So to the degree that we can alleviate that for young people because the law allows it, to us it seems really aligned with our work. For many young people in the state of Washington, even returning into the public high school system with a juvenile record is a barrier. Certainly, we've had lots of examples of young people who were not able to transition successfully into housing independently on their own as they got older because of criminal records. And being able to seal that record specifically is really instrumental to them launching themselves into living independently and being able to support themselves. So we've had a lot of different collaborations. We've had great partnerships with, in every place that we've worked on record sealing, the partnerships with the public defenders have been really strong because they've been really willing to help even when they've been limited in their ability to do the actual record sealing themselves, but to help us get access to the information we need to be able to help people assess eligibility. The most recent thing we've done that I think was pretty, it was pretty fun for us. It involved another partnership with a law school, but then it also involved partnerships with local public defender offices, which is that we had a law school who had a practice of, during their week-long spring break, the law students were to go out and do a pro bono project. So we had a team of 10 law students come to the state of Washington for their spring break week, and we set up 3 pop-up record sealing clinics in 3 somewhat rural, remote areas of the state. And we partnered with a lot of people, libraries and community colleges, as well as the public defender and civil legal services offices in those communities to set up access, you know, computer access and printers and information access for eligibility and getting the word out so that we could try to allow young people to seal records in places where Team Child doesn't have an office or a presence, so we're not able to make that access through our presence, and where obviously public defender, other civil legal services offices aren't really doing that work. So it's another kind of innovative thing to try. But we've been looking at the ways of trying to get the word out and getting people access to record sealing kind of from as many ways as we can think about it, and pulling in as many partners as we can.
So Karen, how many locations in Washington did you do that spring break project in?
3. We set up 3 times. We did it 3 times, 3 small communities, somewhat rural communities. I mean, they're not that small, but more rural than the big cities.
Gotcha. And I think that's important too, is making sure things are accessible to people. And that's awesome that you guys worked with partners and you know, really went out of your way to make sure to make record clearance accessible to folks in rural and remote communities. So thank you, Karen. The work that these offices have done is pretty amazing, and I'm excited that they continue to do more and more, and they're innovative in what they do. And Karen and JC are available to answer any questions that you guys have at the end also. So there's lots of resources and tools that you can refer to as you're trying to do this work. There's the Clean Slate Clearinghouse website that Alex talked about earlier, has all sorts of resources in there to help figure out what the statutes are in each state, what the process is, and who are the people who are currently doing the work in each state. It's also important to think about law school clinics. It's one of the things that Karen had mentioned is partnerships with law school clinics. They're eager to get experience and understand that these are real barriers and issues, and try to take advantage of those possibilities in your area as much as you are able to do so. Workforce development is also a great partner and resource in this work. As you're trying to reach out and find the young people in your community that need help, oftentimes they're going to their local workforce development office for help. They don't maybe understand that what they need is help with clearing their record, but what you as practitioners can do is go to those offices and educate the folks who are working at the workforce development offices so that they understand what a juvenile record can cause barriers, why it's important to clear the record, and what they can do to get their record cleared. Where can they go? Their local civil legal aid office, their local public defender office, to get help with representation in that process. Recreation centers are another place that you can oftentimes build relationships with and get the word out to young people that this is something that they need to take advantage of. And local places of worship along with other community organizations. Making sure that the folks who are working with young people on the ground every day understand the process, who they can go to, and that you as a defender or civil legal aid attorney or other community service provider can be a resource for information related to these things. The National Juvenile Defenders Center's website is also has a lot of resources and information on them. It is, we have state-specific resources, as you could tell between the conversations that we had, specifically with JC and Karen, that states treat these things different, and therefore it really depends on what state you are in, the level of consequences a young person might face because of their juvenile court involvement, and the record clearance process varies by every single state. So there are state-specific resources on our website, njbc.info/collateral-consequences that are also available to answer questions or address your issues. So thank you guys so much for participating with us, and we are available to answer your questions. Karen and JC and I are here and ready to talk with you all a little bit more and hopefully address any issues or questions or concerns that you might have. So we have a question of, is it legal in every state to refuse services to adults based on having a juvenile record? So as I mentioned just a minute ago, everything generally is different by state. It depends on what we're talking about. You know, many of you may have heard a ban the box movement throughout the country. Oftentimes those don't really include juvenile adjudications, and that's a thing that we're trying to help people understand, that if you're banning the box and you mean to also include preventing people from asking questions about juvenile records, then you need to be explicit about it, because every state, or almost every state, defines a juvenile adjudication as something that's different than a conviction. So if your campaign work and your movement is trying to make sure that it includes convictions, also try to make sure it includes juvenile adjudications so that people are not allowed to ask questions about juvenile records in addition to adult records. Another question is, why can't public defenders help with record clearance in some places? So for example, each state has a different way of funding and providing public defense services. So some states have a statewide system. like Maryland, where there is a state public defender who is head of the statewide office and then has different divisions in each county and has individual attorneys on the ground. Then there are states like in Washington, where Karen is from and what she was talking about, where they do things different in each county. It is funded by the counties and it works and operates different. So each county figures out how they're going to fund and how they're going to set up their juvenile defense system. And so most of it is done by a contract with the county. There are entities that contract with the county to provide those services. And they've worked at a different system in King County, and maybe they've done it in a couple other counties too, but mostly it is done by a contract. And for that contract, there's usually parameters about what the defender's job is and how far that attorney can represent and still get paid to do the work and still be covered underneath the malpractice insurance to do the work. And many times, record clearance is not included in that contract. We are working with entities, state and local, nationwide to encourage them to make sure that their contracts do include this work because of the importance. But when it's outside of their contract, they don't really actually have the opportunity or ability to do so. So that's just one example of when there is an issue and why some defender offices are not able to provide representation. Karen or JC, do you have other experiences why some defender offices have been unable to provide services and for record clearance?
Just kind of the same thing that you said, at least in Lancaster County and kind of like Washington, every county is different, but the public defenders here don't have access or are ordered off of the case either at the post-dispositional phase or once the case closes, and then the sealing process is initiated after that. So that's why they can't assist them, because they are not on that case anymore. So they're kind of limited by that, and that's why we started that whole collaboration with them, is so that we could do what they could not.
And then this is Karen, and I would say in Washington State right now, we actually are working on a somewhat systemic problem, which is that in some jurisdictions, the court has decided the motion should be filed under a civil cause number. And so specifically, if making this motion is a civil cause number required to be filed in the civil court, then that would restrict a public defender from doing it. And I've had that experience working with some attorneys in other states who are helping me with clients that I have here who need relief from other states, that to ask the court to seal a record is a civil motion. So that'd be another example of why that's hard for a public defender to do.
And here's another question that I think would be great for you to answer, Karen, is how do you reach out to your subject population? How do you advertise your record clearance events? Have you had success doing regular clinics, and what does the turnout look like?
We have had a real mixed bag, and we think and talk all the time about how to get the word out better. Some of our best partners for addressing record sealing are community colleges, because it just hits a perfect time in a person's life where because you have to wait 2 or 5 years in the state of Washington to seal your record, and a couple other factors, but there's definitely a waiting time, which usually means that you do have to be slightly older. I mean, obviously, if you were adjudicated at 12, you could be eligible at 14, but for a lot of people, you know, it's going to take you a couple years to be eligible. So we found community colleges to be a great time, and it's also hits a target population of people who are thinking a lot about their future. So they're thinking a lot about wanting to make their future as best as possible, so then wanting to address that juvenile record. I agree, like Serena said, workforce programming, anyone who's helping people with job training or job employment. We've had a lot of referrals from programs like that who are helping kids aging out of foster care with employment skills, or just other either government or nonprofit groups that are focused on helping young people learn job skills. So they're really thinking about their future. It's a time that they're getting a lot of collaboration. We've also had incredible partnership with libraries. Libraries love to promote this information. So we have found them to be really eager to help us get the word out about this. And then maybe one thing just to address the attendance. We stopped doing clinics monthly for a whole variety of reasons, but we really felt like at the time that we stopped doing them that we would want to, we were thinking a lot about how to do this statewide, even though we don't have a presence statewide, but we were really thinking a lot about how to do it in a way that is the most efficient. And it is a lot of legwork for maybe a smaller group of people, right? So our clinic probably averaged, I don't know, 5 to 20 people a month. So some months a lot, some months less. So it was just hard always to predict, how many people we needed available. And so it is definitely, having just a regular standing clinic time is, we didn't get great at knowing how to fill it every month in a really consistent way.
In my, this is Serena again, and in my experience, the best way to communicate and do outreach with the community is to figure out who's already serving the young people that you're trying to reach out to. No need to reinvent the wheel, but figure out who those people are and what are the issues that they're facing, what organizations are addressing those issues, who's already built those trusting relationships with young people where they're going to get daily or weekly assistance from. Oftentimes there's maybe a YMCA, there may be a homeless shelter, there may be a job service, job training organization, something like that that is already serving young folks who may have had juvenile court involvement that you can then tap into. And I think that's very, very important to keep in mind and try to reach out that way. Many houses of worship, as I mentioned earlier, are also really connected. Recreation centers, community organizations that are on the ground interacting with young people regularly. I think it's important that we work with them to make sure that, we break through the myth that juvenile records are not a big deal. We break through the myth that juvenile records will never come up and be a problem in a young person's life again. We help people understand the collateral consequences and why it's important to get a record cleared so that young people then will exercise the effort needed to do so. Many times it's not an easy process. So there's a waiting period, there might be a filing fee, they might need to go get a copy of their official record from the state law enforcement agency. There might be all sorts of aspects to this process that's just not an easy thing. We just need to help people understand why it's important to do it anyway. And taking our time to make sure that we communicate that effectively, I think, is important. One other question that we have presented to us is there funding or legal service providers to add record clearance attorneys to staff? There have been many grants provided along this area. I think that the Office of Juvenile Justice and Delinquency Prevention is very much interested in ensuring that young people who are eligible to get their records cleared do so. They are currently funding 7 sites to do this work, and they're also providing other civil legal services for young people who have been involved in the juvenile court system. But outside of that, I think one great way is that people connect with recent graduates or people who are about to graduate to apply for SCADN fellowships or OSF fellowships or other things like that, equal justice works that they can utilize that fellowship as an opportunity to do this type of work. Finding someone who can get into your office and help you create those relationships and develop that partnership and focus on record clearance taking advantage of fellowships to do that, I think, is very helpful. And then, there's a lot of community organizations that very much care about these issues. We just have to do a better job at communicating the importance of it and why it takes more funding to do so than what the state or local government has put behind it. Anybody else have any input on JC or Karen on funding for civil legal service providers to add record clearance attorneys to their staff?
We were really grateful to partner with NJDC to have a fellow for a year. And I do have to say, having someone develop the expertise has really expanded our work. So having that fellow who specifically and exclusively worked on these issues has made it possible for us as an organization to really grow in the work.
And our juvenile reentry project is one of those funded by the OJJDP grant, so kind of exactly what you said, Serena.
There's one other question: that are there resources for lawyers who are interested in helping with juvenile record sealing but haven't done it before? And absolutely, I think the main resource I would point you back to is the Clean Slate Clearinghouse website, www.cleanslateclearinghouse.org. There's all the basic information you want to find out about record clearance in every single state. And the territory, sorry, let me not forget the territories, that you can find out the statutes, you can figure out the waiting periods, the fees required, and who may already be doing the work in your area. Always great to start a partnership with an organization that's already doing some work and can help you figure out maybe where there's some gaps where you can start moving into and helping out with. And if you want, feel free to reach out to me. I'd be happy to have a conversation with you about building those relationships with public defender offices and figure out where those gaps are that you could really help pick up the slack and help young people and get a record clearance project up and running. Be very happy to help with those type things.
This is Karen from Team Child. I would just weigh in. If you're in Washington State and you're thinking about it, please call us. We will help and help and help.
And Team Child has a great website with lots of resources on this issue. So if you are in Washington State, give them a call, look up their website. They have lots of wonderful written materials in addition to major experts in their office to help. So thank you, everybody, for participating today. Please feel free to reach out if you have any questions. We're very grateful for your time and hope that that has been helpful and encourages you to go out and build those partnerships.
Our thanks to today's presenters. If anyone has additional questions, you may email the presenters directly or email cleanslate@csgjusticecenter.org. We encourage you to sign up for our newsletter at cleanslateclearinghouse.org to receive information on future webinars like this one and other announcements. We also encourage you to spread the word about the Clean Slate Clearinghouse in your networks. Thank you for joining the webinar today.